This Honorable Court of Tennessee is now in session. You may be seated.
Good afternoon. A reminder, unless we have put an order down, and I don't think we have in this case, that this oral arguments will be live streamed as part of our making this courtroom as open to the public as we can. And then after that, it will be placed on the administrative office website. So, yes, sir. I haven't. Who's it?
It was denied by the clerk. I received the order yesterday.
I'm sorry.
It was denied by the clerk. I received the order in the mail yesterday.
Oh, so we addressed it. Okay. That's okay. That's okay. If we got EFD, you probably may not have gotten it yet. We rarely do it, frankly, unless it involves children, something like that. Of course, matters here are almost always private, and people would prefer to keep them that way, but our courts are open to the public to make sure that we're doing what we're supposed to be doing. So, call the case, please.
Janett Galloway versus Earl Scott et al.
We'll hear from the appellant. Yes, sir. You. Mr. Scott, let me explain some things to you here. You may already know this, but I want to make sure that we're all on the same page. Each side has 15 minutes. Since you're the appellant, you have the option, if you want, to reserve some of your 15 minutes to go and rebuttal after your opponent here does their time. But you have 15 minutes total, so if you wanted to, you can use it all now and not reserve any, or you can reserve a few minutes for rebuttal.
Yes, sir, Your Honor. Please, I would like to reserve 3 minutes.
3 minutes, that'll be fine. You proceed.
May it please the court, my name is Earl Dwayne Scott II, representing myself and my wife, Lisa Scott. We are here today seeking fair resolution to a boundary dispute concerning less than 2 acres of our land.
Mr. Scott, I'm sorry, could you stand more in front of the microphone so we can hear? Thank you.
We are here today seeking fair resolution to a boundary dispute concerning less than 2 acres of our land focused on our western border. This includes a gas line easement installed by one of my ancestors, U.K. Jones, Jeremiah Jones. It was land that was in our family for generations. Key legal argument. There are 3 main legal issues I wish to address today. Conflicting surveys. The Chancery Court wrongly relied on flawed surveys from 1985 to 2010 by C. Eugene Olmsted, despite known errors such as line closures, gores, and gaps. Even the plaintiff's surveyor, Adam Leftwich, admitted these surveys contained inconsistencies and testified that such errors were common in Olmsted's work. In contrast, Donna Cantrell, a highly regarded surveyor with decades of experience, provided a more reliable survey based on historical accuracy and physical landmarks, which the court should have considered. Improper property allocation. The courts awarded a portion of our driveways, septic tank, and field lines to the appellee without requiring her to prove adverse possession or prescriptive easement. This decision was made without evidence regarding adverse impact it had on us and the use of our property. Malicious prosecution and financial harm. This litigation has caused us nearly $100,000 and forced us to leave our primary residence. The appellee's actions amount to malicious prosecution, and we respectfully request compensation for the financial and emotional harm we have suffered. Statement of facts. This dispute involves a small tract of land, primarily our western border, which includes a gas line easement developed by Hugh K. Jones in the 1940s. Key testimony, such as that of James Shannon, confirmed that the gas line easement was installed and with full knowledge and consent of Hugh K. Jones, establishing our rightful ownership. The conflict stems from inaccurate surveys conducted by C. Eugene Olmsted. These surveys failed to properly close the critical boundary lines, an issue confirmed by Adam Leftwich. Despite this, the Chancery Court relied on these flawed surveys in its decision, ignoring more accurate historical evidence and physical landmarks. Moreover, our 1976 deed of correction extended our northern boundary, giving us color of title. We have met all the requirements for adverse possession and under color of title, which only requires 7 years of use. Our claim to this property is further strengthened by this deed of land's open, continuous, and exclusive use. Survey inconsistent in boundary clarification. The reliance on the Olmsted surveys violates Tennessee Code annotated 66-5-106, which demands clear and precise boundary delineation. The court disregarded substantial evidence, including testimony of Hugh K. Jones and physical landmarks, such as the old road clearly described in Donna Contrell's surveys. This road is also visible in USGS maps and map box data. You can just open your phone and see it. The case law in McCord versus Hayes, McKinney versus Duncan emphasized the importance of historical usage and physical landmarks over inconsistent surveys. These cases make it clear that the surveys alone, particularly when flawed, should not be the sole determinant in boundary disputes. Furthermore, the old road was located on the plaintiff's property as detailed in our survey. The gas line easement, which is not an old road, the original road lies approximately 25 feet west of the gas line at the southwest corner and 45 feet at the northwest corner of this concerned boundary dispute. Property allocation, adverse possession. The court erred in awarding the parts of our property, including driveway and septic tank system, to the appellee without requiring them to meet standards of adverse possession under Tennessee law, which demands continuous, open, and adverse use for at least 20 years. There is no evidence supporting their claim. The appellant herself testified not having used the disputed area. My wife grew up riding her pony in that area. Her grandfather built a fence. This property is in use of our family, not hers. Cases such as Favere and versus Hunt, Stone versus Beckley highlight the necessity of proving exclusive use, which the appellee has failed to demonstrate on the Chancery Court's allocation made without legal justification, infringing on our rights to the property. Monetary compensation and malicious prosecution, the financial burden of this litigation has been devastating. The appellee has dragged us through years of baseless legal proceeding, costing us nearly $100,000, causing significant emotional and physical distress. Under Bell versus Real, Snyder versus Eichert, we have grounds for monetary compensation due to malicious prosecution and the abuse process. The prolonged litigation, combined with the lack of legal basis, demonstrates the appellee's intent to harass us further in supporting our claim. Your Honors, this case is about more than just land. It's about correcting an injustice. The court relied on faulty surveys, ignored historical evidence, and applied adverse possession law incorrectly, all of which led to an unfair decision. We respectfully request this court to reverse the lower court's ruling, restore the boundaries established by historical evidence, and compensate us for our financial and emotional harm we have endured. Additional concise summary for oral boundary easement clarification. The old road located on the plaintiff's property, not on the gas line easement. The road lies approximately 25 feet to the west-southwest corner and 45 feet west at the northwest corner. Historical deed reference. Consistent deed calls from 1938 to 1950 confirmed the old road's location, including transfers involving H.K. Jones, Hurricane Galloway, Hoy V. Davis, and Arnold Funeral Home. Mineral rights and legal proceedings. Arnold Funeral Home reserved mineral rights in 1939, which clouded H.W. Galloway's property. These rights were divested in 1981 by Chancellor Billy Joe White. Now I ask you, can you have control over a property you just sold? The only one in control of that property was my ancestor, Hugh K. Jones. He developed and installed that gas line easement. The gas line easement is the whole bulk of this boundary issue. That is in court recorded testimony. It's not hearsay. It is testimony accepted. Misrepresentation of easement. The appellee, Janett, falsely claims the gas line easement as a road despite the lease predating her ownership of the property. The court case and testimony, 1948 course case, confirmed H.K. Jones' ownership, location of the land gas pipeline, case number 3147. Testimonies confirmed the easement's existence and the property's chain of title. I'm sorry. Conflicting. Your Honors, this case is about more than just land. It's about correcting injustice. The court relied on faulty surveys, ignored historical evidence, and applied adverse possession law incorrectly, all of which led to an unfair decision. We respectfully ask this court to reverse the lower court ruling and restore the boundaries established and compensate us for financial and emotional harm we have endured. That's all I have. I want to reserve 3 minutes.
You have your time for rebuttal, sir.
Thank you.
Thank you. We'll hear from the appellee now.
Good morning. No, that's not right. Good afternoon.
Yes.
May it please the court, I'm Dale Montpelier, and I represent the plaintiff and appellee Janett Galloway. I stand in this case the same as Your Honors. I was not the trial lawyer, had nothing to do with the trial court proceedings. I was hired specifically and solely to address this appeal. So I came to this case with the same vantage point as you did. I know nothing except what is in the record. I have studied the record, and I studied the trial transcript, and I can't stand here and say anyway that Chancellor McFarland erred. I noticed the reference to Billy Joe White. I think we all miss Billy Joe White. He was a fine judge. And I think Chancellor White would have come to the same conclusions Chancellor McFarland did. At the very core of this dispute, it's a battle of the experts. The only real testimony was 2 experts. Chancellor McFarland, his findings are entitled to great weight on appeal. And his decision on the credibility of witnesses, that's not even subject to review. Chancellor McFarland said at the trial and on the record that he found the plaintiff's expert to be more credible. And he selected that survey from which he rendered his decision. The defendant, the appellants, they make no reference to the record on how the chancellor was in error. Now, again, I studied the record. I'm sure you will study the record. But it was still the duty of the appellant to point out these errors and where these errors on appeal were preserved. Now, several concepts are brought up. The first one, prescriptive easement. There's no reference in the pleadings to prescriptive easement, and it wasn't mentioned at trial. There was brief discussion of a gas easement, but that really has no pertinent, germane bearing to the issue. There was also argument on adverse possession, and you heard the rendition of the elements and how the appellants feel that they satisfied it. The problem is that their attorney explicitly withdrew adverse possession as that trial was about to start. And it's where the phrase, a day late and a dollar short, applies. It shouldn't have been waived if they wanted to raise it as an issue on appeal, but it was waived, and that door is closed. There was reference to Tennessee Code annotated 66-5-106. I can't see how this applies to the case. Today there was discussion of malicious prosecution and abusive process with claims that these were baseless legal proceedings. Now, I don't take joy standing here taking issue with a pro se litigant's arguments, but I'm compelled to do so. There's no malicious prosecution or abusive process pled in this case. I can't see where it was argued in the appeal. These clearly were not baseless legal proceedings. Ms. Galloway prevailed. So I don't think that argument is going to work either. Another issue that is raised in the brief, and I didn't hear it in oral argument, was the property allocation and the impact. Again, there was no reference to the record to explain how the property allocation was wrong, what the impact was, how it was negative, or even how it's relevant to this appeal. In fact, the review of the transcript shows that there was no evidence presented to discuss any kind of negative impact. So this really does come down to a straight question of law based on the evidence of the expert witnesses. And Chancellor McFarland, God bless him, he makes errors like the rest of us, but not in this case. Finally, Your Honors, attorney's fees on appeal, and I know they are rarely granted, and rightfully so. As I read the cases that come out every night, the new decisions, it is rare to find a case where you have awarded attorney's fees to a litigant. But I have to say, in 30 years of doing this, I've finally come across my first case where it's warranted. With all due respect to the appellant, and I understand that land can be very personal to someone, and they can be passionate about it, but they still put Ms. Galloway to expense that she should not have been put to. And I would respectfully submit, based on the briefs and based on the argument, and again, it pains me to say it, but this appeal is utterly devoid of merit and had no chance of success. Ms. Galloway should not be forced to bear that expense under these circumstances. And she therefore requests that you exercise your discretion and award her those fees. I didn't need but half of my time. I'm happy to answer any questions you have.
I hear none.
Thank you for your time.
Scott will hear you in rebuttal.
Thank you, Your Honors. Case law: to establish public road by implication, the proponent must satisfy two requirements. First, landowner must indeed dedicate the road to the public. McCord versus Hayes, 302, SW 2D 331 333, Tennessee, 1957. Second, the public must expressly or impliedly accept the road, i.e. the burden of proof is heavy. In short, the proponent must present proof of facts from which the owner intended to permanently part with his property and invest it in the public, and that there can be no other reasonable explanation of the conduct. In other words, dedication to question of intention, and intent must clearly and satisfactorily be proven. McKinney versus Duncan, 118, SW 683, 684, Tennessee, 1909. Failure to adequately prove these elements should not result in an unjust reward. The trial court found dedication be public use. Permitting public use can't imply dedication. Cole v. Ditch, 535 SW.2D 315 319, Tennessee, 1976. But other than the Scotts, no one except the Scott predecessors have used the gas line easement. Thus, dedication by public use has not been established. An easement is an interest in another's real property that confers the easement holder an enforceable right to use the real property for a specific use. Brew v. Damon, 53, Tennessee, 6, Heisk, 433, 436, 1871. The most ordinary form of easement is the right passage across another property. Shaw v. Bogus, 227, SW, 3D, 596, and 569 and 578, Tennessee Court of Appeal, 2007. Evidence from the record. Crucially, there exists a lack of clear and compelling evidence from the record that substantiates plaintiff's assertions of adverse position and prescriptive easements. This deficiency underscores the unjust nature of the award portion of the defendant's property tracking. In order to establish requisite 20-year prescriptive period, party has the right to tack on adverse to this predecessor's title. See Laurel Valley Property Owners Association v. Hollingsworth, number E 2003-01936, COA R3 CV 2004 WL 149404 at 8 Tennessee Court of Appeals, June 29, 2004. The concept of tacking allows one to claiming prescriptive easement to add his or her period of predecessor's period of use in order to establish requisite prescriptive period. Tacking requires that the combined periods successive that each possession meet the requirements and elements of the prescriptive easement. Court stated the general rule that successive adverse possessions cannot be tacked unless predecessors are, I'm sorry, Your Honors.
You can finish up, give you a little bit to finish up. Your time is up, but go kind of wind it up.
Yes, sir, thank you. In Thompson, the court stated the general rule that successive adverse possessions cannot be tacked unless possessors are connected by some form of legal privity, which is applied in Eric v. Church, Supra, and Ferguson v. Prince, 136 Tennessee 543, 190 SW 548. However, the rule is subject to exceptions. The Rempert v. Edmondson, 99 Tennessee 15, 41 SW 93563 AM State ST REP 819, a parole understanding that a strip of the rear lot that a strip on the rear lot of a lot conveyed by deed would go with the lot to the extent the grantor had any title to convey was held to supply necessary privity, although the strip adjoining the lot conveyed was not within the cause of the deed. So, see also Tuggle v. Southern Railway Company, 140 Tennessee.
And Mr. Scott, you used your time, sir.
The Chancery's Court's award of a portion of the defendant's property to plaintiff was unsupported by substantial evidence for adverse possession and prescriptive evidence as required by Tennessee Code and 282-101. Adverse hostile, and under the claim of right, we conclude that we're entitled to this property. Thank you very much, Judge.
Okay, thank you.
Thank you, sir.
Scott, again, you may understand the process, but the way it works is we'll take your appeal under advisement, then we'll issue a written opinion or decision, and we'll send it to you and your opponent here at the same time. So that's how you'll be notified.
But that will be through the mail, Your Honor, sir.
We generally do a paper opinion, but you also have the option of having the opinion emailed to you as well.
Yeah, email would be fine with me.
Okay, just make sure that you stop by the clerk's office and make sure we have your email address in your court file.
Yes, ma'am.
And we'll be happy to do that for
Just
you.
right across the hall from us, so just make sure they've got it, and that way you'll get it.
Yes, sir.
Okay.
Thank you, Your Honor.
Adjourn court till tomorrow morning at 9:30 a.m.
All rise. This honorable court of Tennessee now stands adjourned until 9:30 tomorrow morning. You'll still get a hard copy of the opinion as well. So you'll get a hard copy of the opinion in the mail, and then you'll get an email version